Good afternoon. Welcome to the Sister Distinguished Practitioner Lecture. My name is Calvin Sharp, and I am the Director of the Center for the Interdisciplinary Study of Conflict and Dispute Resolution. We use the acronym SISTER. Shortly after we launched the Center, I was doing an interview with Miss D. Perry at the local NPR affiliate, WCPN, and after she managed to give the fairly long name of the Center, she referred to the acronym SISTER, and she said on the air, "Thank you for the acronym." Those of you who have followed our lecture series will recall that we feature highly distinguished legal scholars, interdisciplinary scholars, and practitioners. I am excited that this afternoon we are featuring, as you will see, a highly distinguished international arbitrator for the first time in the lecture series. Sister owes a debt of gratitude to Professor Il-Hyung Lee, who was himself a distinguished scholar in the series and is now a visiting professor here from the University of Missouri. Professor Lee was quite instrumental in helping us to attract today's lecturer. He has also graciously agreed to introduce our speaker. Professor Lee.
Thank you everyone for coming. I'm sure that applause was for Professor Sharp and not me, but thank you all the same. As Professor Sharp indicated, this year's distinguished visiting practitioner is the very first international arbitrator in the SISTER lecture series. Fortunately for the law school and SISTER and our guests, our speaker today is at the very top of his field, his profession. I mentioned to my students this morning that he is indeed a movie star in the field of international commercial arbitration. It might take me most of the hour to cover all of his achievements, so I'd just like to give you a flavor of his work and his expertise. David W. Rifkin is a partner at the international law firm of Debevoise Plimpton, where he directs the international arbitration practice from the London and New York offices. He is an honors graduate of Yale University, earning his undergraduate and law degrees. And after completing his studies, he was a law clerk to the Honorable Luther Swigert, U.S. Court of Appeals for the Seventh Circuit in Chicago. Then he joined the firm where he has been in practice for the last 30 years. During his years in practice, he has served as litigation and arbitration counsel, successfully representing multinational corporations such as Hyundai, ExxonMobil, General Electric, Occidental Petroleum, among many others, and winning favorable awards and settlements. Over the years, his work has been recognized by leading international organizations and publications. He has been described as, and I'm quoting, a true giant in the field, a star in international arbitration, the top arbitration lawyer in the United States. Mr. Rivkin has served as arbitration counsel or as an arbitrator in arbitration matters administered by the International Chamber of Commerce, International Center for Dispute Resolution, the London Court of International Arbitration, the American Arbitration Association, World Intellectual Property Organization, the China International Economic and Trade Arbitration Commission, and my favorite, the Court of Arbitration for Sport, as Mr. Rivkin has served as an on-site arbitrator in 3 Summer and Winter Olympics. In addition, our guest speaker is also a forward thinker and a scholar in the field of international arbitration, having authored or co-authored 4 books and more than 30 articles. Finally, he's a very active member of the profession, the bar, indeed the international bar, has served on the Council on Foreign Relations, the Executive Committee of the Board of Directors of the American Arbitration Association, and currently as Secretary General of the International Bar Association. I think I've given you a sense of our speaker's standing. hope you'll agree that few persons are more qualified to speak on the topic today's lecture, entitled Making International Arbitration Suitable for the 21st Century. Please join me in welcoming David Rivkin.
Thank you very much, Il Young, for that very warm introduction. I think I'll invite you to introduce me whenever I'm giving a speech. I appreciate it. And thank you to Professor Sharp and to Case Western for inviting me to come speak today. It's quite an honor. I didn't know I was the first international arbitration lecturer in the series, and it is a very nice honor. It's nice to be here in Cleveland today. It's also nice to be indoors, given what I understand, given the, both the weather and the lions and tigers that I understand are roaming around Ohio at the moment. So thank you very much for coming today to hear this. My talk is on making international arbitration suitable for the 21st century. It really never in the history of international arbitration has it been both frequently used and so frequently criticized. International arbitrations have grown remarkably in number, in size, and in scope. Who would have thought a decade ago that a leading publication could publish details of literally dozens of cases with values of claims over $1 billion, which the American lawyer now does on a regular basis? Regions like Asia and Latin America have thriving international arbitration practices where, again, little existed not so long ago. Arbitrators decide not only large commercial disputes, but also investment treaty cases dealing with matters of substantial public policy. There are even strong young international arbitrator groups throughout the world, and I often remind those young practitioners who flock to them that when I was their age, the Young Arbitrator Forum was often Henry Alvarez, a leading lawyer from Canada, and me sitting together in the back of the room watching other greats such as Berthold Goldman and Pierre Lalive, who were many, many years older than us. But this success has come as a price. More and more, one hears the real users of international arbitration, the corporations and the states who are parties, complain about the process and urge that it is not serving their needs. The length and cost of cases have grown considerably. At least that is the common wisdom, and frequently that's all that matters. A recent study by the Queen Mary International Arbitration Center in the University of London, a survey of major companies from around the world showed that 50% have been disappointed with their experience in international arbitration and with arbitrator performance. Now, in some ways, that is exactly the figure one would expect, since about half the parties win and half the parties lose in any given case. But when the survey asked the respondents for the reasons for their disappointment, about half cited problems related to the management of the case itself, rather than the outcome, poor reasoning, or lack of knowledge. They cited overly flexible procedures and a failure to control the process. They said that the arbitrators themselves caused delays, and they cited the arbitrators' tardiness in rendering the award. It should be noted that more of the respondents blamed the length of proceedings on the parties themselves than on the tribunal and on external counsel. In essence, the respondents asked to be saved from themselves because they believe that the tribunal is in the best position, quote, to render arbitration expeditious by keeping themselves and the parties to the timetable, end of quote. A similar percentage felt that the arbitration institution is in the best position to control the time and costs. The old aphorism that one party wants expedition while the other wants delay, I think, is no longer true. Given the pressure of corporate life today, companies and their executives need resolution. They need clarity and they need closure. In the days of a 24-hour news cycle, and a 24-month arbitration is simply not acceptable. A recent survey of investment treaty awards that have been issued at ICSID, the International Center for the Settlement of Investment Disputes, the World Bank Center for such arbitrations, found that on average, arbitrators took 15 to 18 months after the closing of hearings to render their awards. That is simply not acceptable in today's world. And with time and delay, of course, come additional costs. The longer a case runs, the more it's going to cost. Work tends to fill up the time that's available. A survey issued just a couple of months ago by the Chartered Institute of Arbitrators in London had some very interesting figures about cost, but the most interesting one I thought was this one. In claims that were under £1 million, 50% of those cases, 50% of the parties reported costs greater than £250,000. That means that in half of the costs, half of those cases, the costs were more than a quarter of what was at stake. Again, that simply seems too high, and that's why I've chosen to address this topic in the lecture today. Before discussing some specific ways in which international arbitration procedures can be reshaped, let me begin with a more fundamental change in focus. Too often, counsel in international arbitration seek to conduct cases in the same manner they have conducted other arbitrations, or, even worse, in the same manner in which they would conduct a state court litigation. We know that arbitrators have long-form standard procedural orders that they apply in every case. In one case where I sat as chair of a tribunal, the parties presented me at the first procedural conference with a draft procedural order that was simply a markup of one that I had used in another case involving one of the same counsel, even though the cases were about very different issues and the clients in the cases had very different needs. I have to say I tore it up and we started from scratch. Several years ago, first in a speech in Madrid and then in an article published in Arbitration International, which you have in your CLE materials, I argued that in each case, counsel and arbitrators need to bring their experience to bear in shaping the correct procedure for the case. But more importantly, they need to start with a blank slate. I called my approach the town elder model, harking back to the days when arbitration was largely conducted by town elders who heard both sides to the dispute. The town elder would not start with a 20-page procedural order. Rather, he, and it was almost always a he in those days, would first listen to the party's description of the dispute. Only after gaining some understanding would he then decide whether there might be individuals who could help inform him more about the underlying facts, or would ask whether certain documentation would exist. In that same way, I urged then, and I urge now, that arbitrators, counsel, and parties need to think about what procedure is truly necessary for each dispute. I have conducted cases without any discovery. I have conducted cases without any live witness testimony. I have conducted cases where the written submissions were minimal and where the focus was on oral testimony by the witnesses whose credibility the arbitrators needed to determine. In economics, one talks about zero-based budgeting, starting from scratch and building in what is appropriate and necessary for the annual budget, rather than simply carrying over programs from one year to the next. That should be our approach in all of our arbitration cases. We can effectively deliver fair and efficient arbitration with much less procedure than we generally use now. In determining the procedures for each case, we need to ask about each step in the process. Is it necessary? Will it provide information that is needed to decide the issues in the case? It is clearly incumbent on everyone involved in the international arbitration process to rethink, reshape, and improve the process. All of us, arbitrators, arbitral institutions, outside counsel, and inside counsel, share responsibility, and all of us are in a position to make the process better and more responsive to the needs of the users. We don't need to throw out the process and start anew, but we do need to find ways to restructure and improve it, or it may fall under the weight of its own success. Before turning to some specifics, let me say that the pressure and attention that some of us have been giving to this concern has begun to show a certain degree of success. As some of you may know, the ICC has recently issued a new set of rules effective January 1 of next year. And these are an excellent example of a new focus on cost efficiency and time efficiency. The new rules provide a clear direction towards efficient case management. Each rule change points in that direction. And I'll give some examples of that as I discuss various procedures in this address, but the ICC is to be praised for these changes and this new focus in their rules. So let me now talk about each of the principal participants in the international arbitration process and how they can help improve the system. And let me begin in a perhaps unusual place in discussing who needs to structure this arbitration process, and that is with in-house counsel and the parties themselves. In-house counsel are often heard criticizing international arbitration and its time and its cost. But with few exceptions, there is not much involvement by them in the organization and administration of the process and in the actual improvement of the process. There is a group, as you might know, called the Corporate Counsel International Arbitration Group, which is mostly European. It involves representatives of GE, ExxonMobil, Nestle, Siemens, and some others. And they have a certain degree of involvement with institutions, but not a lot. They tend to spend more time, perhaps, talking among each other than working to change. But their voice has begun to be heard. But you don't find in-house counsel generally on the boards of institutions working to change the rules and focusing and attending seminars where these issues are discussed and where ideas percolate and start to be used. It's very important that that the in-house counsel participate in all phases of arbitrations in which their companies are involved, especially the procedural conferences, to make sure that the arbitrators understand their needs for the case and also for them to hear from the arbitrators so that appropriate procedures can be developed. It's important for in-house counsel to focus on efficiency and not just on winning. It doesn't cost more to win a case. Often, in fact, a winning strategy is creative and is a shortcut in procedures. I'll describe one a little bit later when I'm talking about what external counsel can do, but it effectively involved determining a preliminary issue at a very early stage of the case, which saved a lot of money. Arbitrators, when they are challenged on the time and cost, often say, don't blame us, blame the parties. The parties want all this procedure, it's their agreement that created us, and therefore that's what really drives the costs. It's up to in-house counsel to make sure that they can't blame the parties and that the in-house counsel are making clear their focus on efficiency. All of us who are outside counsel know how much time our clients now spend on working with us to get discounts on our fees, to fix our fees or cap them or create other alternative billing arrangements. If they spent, frankly, the same amount of time focusing on the procedures that would be followed in the cases, they would end up saving far more money for their companies than on focusing on an extra 5% off of the rates of their external counsel. By focusing on efficient procedures, they will be able to drive international arbitration in an appropriate way. And I hope that they will find a way to become more involved. Some companies who are frequently involved in international arbitrations have taken excellent steps in this direction. They have focused all of their international arbitration into certain groups, either individual lawyers or small groups of lawyers who handle all of their international arbitrations, no matter which business unit, no matter where it arises in the world, so that their experience can grow from case to case and they can bring that to bear. There ought to be more of that within companies. And more importantly, those companies that have done that and that have developed the experience need to teach other in-house counsel, because they will listen more, frankly, the in-house counsel to each other than they will to external counsel or even, I dare say, to academics about how to fashion their case. And I would urge perhaps an organization like the CCIG to create a protocol or to create a list of best practices that other less experienced in-house counsel can use when they are faced with an international arbitration. So let me turn then to the arbitrators, because of course they run the process. And in selecting arbitrators, quality and experience are no longer by themselves sufficient qualifications, in my view. The pool of potential arbitrators has grown considerably, and availability and commitment have become necessary qualifications. Parties and their counsel have to do more to confirm the availability of an arbitrator for an early procedural conference and for a hearing at an appropriate early date in the not-too-distant future. And arbitrators need to be more candid about their schedules and decline cases more frequently when they know they are heavily booked. A couple of years ago, the ICC changed its arbitrator acceptance form to include information about the arbitrator's availability, the number of cases that he or she is handling. It raised a bit of a hue and cry from some arbitrators, but it's been quite effective in focusing on that. And in the new ICC rules, Article 11, which imposes certain requirements on the arbitrators, has elevated availability for the case to the same level as independence and impartiality, and that is an excellent move. As counsel, I will be much happier with arbitrators and will call them more frequently to appoint them if they occasionally decline a case when they know that they're simply too busy to handle it on in an appropriately expeditious basis. An arbitrator who accepts appointment but whose schedule then leads to substantial delays will frankly be crossed off our list for future cases. And of course, I recognize that even 3 arbitrators with good availability may not have dates that overlap, but greater availability makes that less likely to happen. One well-known arbitrator says that before she accepts appointment as chair of a tribunal, she checks her schedule against the 2 party-appointed arbitrators who are already in place to make sure that there is sufficient mutual availability. And that is an idea worth following. Once appointed, arbitrators need to view conducting the arbitration in an efficient manner as one of their prime duties. It is as important as making the right decision, and efficiency need not in any way reduce their ability to make the correct decision. Some laws and rules make clear that this is a duty of arbitrators. The English Arbitration Act has a provision making clear that an arbitrator has a duty to conduct an efficient case. The LCIA rules provide for that. And now the ICC in its rules imposes on the arbitrators and the parties the duty to conduct expeditious and cost-effective arbitrations. As I noted earlier, the parties in the Queen Mary study and parties in counsel with whom I've discussed these issues routinely want tribunals to be more proactive in setting appropriate procedures. When they do so, it makes it easier for the outside counsel to agree to less procedure. And the arbitrators should continue to do so at each stage of the case. Whatever procedures may have been set initially, the tribunal can continue to question whether certain evidence, witnesses, or even submissions are still necessary as the case develops. They can reorder the hearing of evidence to sharpen certain issues, again, as they learn more about the case. And so once the case begins, the tribunal needs to take charge. For these reasons, the Queen Mary survey noted, quote, "It was pervasive throughout the questionnaire results and interviews that parties prefer proactive arbitrators who take control of proceedings. This is seen as an effective mechanism to limit the cost and delay and reduce the risks of later challenge. Parties prefer proactive arbitration institutions as well, institutions that firmly adhere to deadlines and communicate effectively with parties." In other words, parties want activist arbitrators. Too often you hear arbitrators say, we have to follow whatever the parties agree to. I disagree with that. There are benefits to an arbitrator being proactive. He can inform and educate the parties and the external counsel about the possibilities. At the beginning of a case, the parties have a strong desire to reach agreement with the arbitrators and to understand where they are driving it. And so at that stage, the arbitrator doesn't need to be a dictator. The arbitrator can be a very effective diplomat in moving the parties towards more efficient procedure. Parties want this. Very often they may suggest greater procedures than are necessary because of certain internal procedures or because of a fear that if they don't propose them and then something goes wrong, somebody will look back at them and wonder why. But if the arbitrators push the parties towards more effective and more efficient arbitration, they can accept it. So arbitrators don't need to fear imposing procedures over and against the agreement of the parties. They sometimes say they must accept the agreement of the parties because not conducting the arbitration in the manner agreed by the parties is a ground for refusing enforcement under the New York Convention. But instead, a skilled, proactive arbitrator can be, as I said, an effective diplomat and can move the parties towards agreement, which precludes any challenge under the New York Convention. So at an early procedural conference, the tribunal has to focus on the issues and the evidence that is truly needed for that dispute. Again, the ICC and its new rules, and I don't mean to be singling out the ICC as the only institution concerned with these. Other institutions have taken steps to control time and costs, but the ICC recently issued these new rules, and the way in which they have changed the rules shows this greater emphasis. So I'm using it frequently as an example. But the ICC has now specifically included an article requiring a case management conference early in the case. This was often implied in determining the terms of reference under the old ICC rules, but it's now explicit in Article 24. When the IBA revised its rules of evidence last year, it also made clear that the tribunal should hold an early case management conference. And Article 24 also makes clear that this is a continuing duty and that the tribunal needs to reconsider these issues as the case develops. As I said earlier, it's important for in-house counsel to be a part of this conversation to make sure that the procedure meets their needs in terms of time and cost and getting to a resolution. While distance often makes it more expedient to hold these conferences by telephone or perhaps video conference, it's been my experience that holding the conferences in person often saves costs later in the case because it allows a more thorough examination of the issues and a more complete consideration of the procedural questions that might arise. And when you hold them in conference, in person, even if it requires a lot of travel by everybody to get there, it ends up saving costs because fewer procedural issues arise unexpectedly in the cases. To give an example of what you can achieve at one of those conferences, let me mention a case where I was chair of a tribunal. The parties, and also what I mean by perhaps the arbitrator both being proactive but also being a diplomat and getting the parties to agreement. In this case, the parties presented an agreed schedule at the procedural conference. And this schedule provided for document production and submissions that would last over an 18 months period before finally getting to a hearing. But the parties' pleadings had shown that the joint venture over which the parties were fighting had come virtually to a standstill because of these disputes. We asked the parties to describe those disputes in greater detail, and then we sent them out of the room to meet separately and then with each other to develop a list of the half-dozen most important issues that the tribunal could decide on an early basis and help alleviate the broader dispute. After a couple of hours, the parties presented the tribunal with such a list. We scheduled a hearing in 3 months with submissions only on those half-dozen issues, most of which were contract interpretation and didn't require extensive evidence. We heard the evidence relevant to those issues and issued a partial award soon after. Not surprisingly, The parties were able to settle the remainder of their disputes once the tribunal had given them these determinations on those issues. So we should use also determination of preliminary issues more frequently. I don't espouse regular summary judgment motions as are common in American or English courts, but arbitration offers possibility that those types of court motions do not. In court, if there's a genuine issue of material fact, the court needs to hear the entire case. In arbitration, if determining a preliminary issue can assist in the overall resolution of the case, the tribunal has the ability to hear the evidence in a factual dispute just on those issues. And we began to refocus the arbitration community in this way when we revised the AAA's international rules back in 1997, and then put a similar provision into the IBA rules of evidence in 1998, and it's begun to take hold. I'll give you an example, and I referred to this a little bit earlier. In one case, we represented a political risk insurer, and the claim by the insured involved expropriation in an African country. It raised very complex issues of fact and of the law of that country as to whether or not an expropriation took place. But we believed, our client believed, that even if there was liability under the policy, no compensation was due because the policy provided that compensation was the amount of the net book value as of the date of expropriation. And documents that the insured had provided to the insurer showed that the net book value on that date was negative. So we asked the arbitrator to put aside the issues of liability. We didn't waive them, but we said, put them aside for now and just hear us on the issue of whether any compensation would be due, even if there was liability. The other side complained. They wanted to present their whole case to show how wronged they were, but fortunately the arbitrator took us up on it. Now there was a factual dispute about what the net book value was on that date. But we made submissions on facts, on those facts, witness statements, documents. We had a one-day evidentiary hearing on that issue, and the arbitrator agreed with us that the net book value was negative on the date of expropriation and dismissed the claim on that basis. If we'd been in court, we couldn't have done it that way, but because we were in arbitration, we could. If we'd had to hear all the issues of liability, it probably would have been a hearing of a couple of weeks, given the complexity of some of the issues. It would have cost far more money. But because we were able to get the arbitrator to focus on this preliminary issue, we resolved that. And what a shame it would have been to spend a couple of weeks fighting on liability and then to win, again, no damages based on what we were able to present in that single day's hearing. I urge parties and arbitrators to use these types of procedures. Again, and I also urge parties to present more detailed statements of the case at an early stage. Because if you have detailed pleadings, it's easier for the arbitrators to be proactive, to think about what procedure is truly needed for that case, and to think about whether there are preliminary issues like the one I just described that may resolve some or all of the case. And also more detailed statements of claim and answers will help the arbitrators control the discovery process. We are worried about an avalanche of paper, or now an avalanche of megabytes in international arbitration for the same reasons we are in litigation. The IBA rules of evidence provide much stricter grounds for producing documents and requesting documents in international arbitration than exist in American court litigation or English court litigation, for example. But still, given the amount of electronic documents that every company keeps, we have to worry about the cost of document production in international arbitration. It is much easier for arbitrators to be proactive and to focus the discovery requests, the document requests, only on those issues that they truly need if you have a more detailed set of pleadings at an early stage. And when we revised the IBA rules of evidence last year, we made another important change in this regard. I mentioned the The general standard for producing documents under the IBA rules of evidence is you can only request a narrow and specific category of documents, and you have to prove that the documents you're seeking are material and relevant to the outcome of the dispute. We added to that to make clear that in meeting those standards, if you are requesting electronic documents, as most do now, a party can simply request search terms or otherwise focus the requests in a manner that makes electronic searching easier. And we hope that this will, again, reduce some time. One other procedural point during the course of the case that where arbitrators, I think, can exercise much greater control is in the use of post-hearing briefs. I generally find that it's a great waste of time and money. By the time the hearing is over, the arbitrators have almost always determined how they'll rule on most, if not all, of the issues. Nevertheless, one party or the other wants another chance to replete its case, or the arbitrators want a roadmap to the evidence to help them in writing the award. Neither is a sufficient justification for adding what could be $250,000 or more to the costs of each side of the case, and for delaying the ultimate resolution of the case by several months. It's incumbent on the parties to exercise self-control and for tribunals to exercise that control if they do not. A closing argument at the end of the hearing allows the tribunal to ask the parties the questions that are most useful to them and to be in a better position to consider the evidence before they deliberate. If there are particular issues of fact or law in which the tribunal wants some further elucidation after the hearing, then the tribunal should direct only focused post-hearing briefs on those issues alone. Most importantly, once the parties and the counsel have done their work, the tribunal needs to do its work, and quickly. That is their duty to the parties. They are paid well to serve as arbitrators, and that is when they earn it. In the Debevoise protocol, which is in your materials and which I'll describe a little bit more in a minute, we commit that we will ask any arbitrator whom we are appointing, whether as party appointed or chair, or as a sole arbitrator, to commit to issuing an award within 3 months after the merits hearing or post-hearing briefs are concluded. There's no reason why it should take any tribunal longer than that. Arbitrators leave the hearing well-informed with fully formed views of the case. And we encourage arbitrators, and when I sit as arbitrator, I encourage this to my panel, that we schedule the day after the hearing to spend the day deliberating while the evidence and the arguments are fresh, and it can lead to a quick resolution. As I said, the recent study that shows that an ICSID award generally takes 15 to 18 months from the end of the hearing to an award brings disrepute to the system. Another arbitrator has said that he makes sure that when he schedules a hearing, he leaves several weeks clear afterwards so that he can write the award immediately. It takes great self-control to do that, but it's very important. And if an arbitrator knows that he's not going to have time to write an award on a timely basis because his hearings are all backed up, he shouldn't accept appointment in the first place. Again, going back to the new ICC rules, the tribunal now, at the time it closes the proceedings, is required to inform the Secretariat of the date it expects to submit an award. Simply by having to put that in writing, it should hopefully encourage tribunals to do so much more quickly. If a tribunal should know that it's not going to be able to say, we'll submit the award in 18 months. If my guess is if they say anything longer than 6 months, the Secretariat is going to pick up the phone and say, you got to do better than that. And simply making that moral commitment should make quite a difference to putting out the awards on a more timely basis. In addition, the ICC has left to itself in the new rules the ability to adjust the fees that they pay to the arbitrators based upon the efficiency of the case, the conduct of the case, and the timeliness of the issuance of the award. So when you put these provisions together, it should give them some real tools. The next party that, of course, can do more to help on time and efficiency is counsel, and I've already talked about that a bit and the way counsel can play a role. Again, the duty that the ICC has put on into its rules to conduct cases efficiently is imposed on the parties and their counsel as well as arbitrators. And the IBA rules of evidence require that the conduct of evidence be conducted in good faith and suggest to arbitrators that they adjust cost awards at the end of a case if they find a party has not acted in good faith. As I said, our counsel cannot conduct cases as if they were simply conducting litigation in their state courts. They need to use the flexibility and the openness of arbitration procedures to conduct cases more efficiently. Last year, we at Debevoise and Plimpton took a step that we hope will help that process. We issued the Debevoise Plimpton Protocol to promote efficiency in international arbitration. It's in your materials. We made a public commitment to explore with our clients whether and how each of the 25 specified procedures can be used in each case to make that arbitration more efficient. We recognize, of course, that the flexibility inherent in international arbitration is one of its advantages. So these procedures are not set in stone as inflexible rules. But we hope that by setting out procedures that promote efficiency and by publicizing it, we hope to encourage other counsel to follow these procedures as appropriate in individual cases. And it's just an example of what counsel can do. I've already talked about how counsel can assist in greater efficiency by providing stronger, more detailed statements of fact and statements of defense early on in the case. If you are a claimant and you show up and it always amazes me, when we're the respondent or when I'm sitting as an arbitrator, when you get to the first procedural conference, which is already several months after the case was filed, because it's taken a few months to put the tribunal in place and then get a conference scheduled, then when the tribunal turns to the claimant and says, when can you submit your memorial? And the claimant says, oh, we're going to need 3 months or 6 months sometimes to submit that. My first thought is, what have you been doing all of this time? We will show up we will have it prepared so that we can give a very short period of time after the procedural conference, if we're the claimant, to get the process moving, and it does. And similarly, the detailed statements of claim, again, we say we will use them in the Debevoise protocol. It allows the parties and the arbitrators to focus on the appropriate procedures. Counsel need also to control themselves when it comes to making document requests. I have to say, in writing every document request, I think, how would I feel if this request were coming back from the other side? Is it appropriate or not? How would my client feel about it? Or do we really need these documents? Again, too often, document requests, even international arbitration, have 50 or 100 different requests, and it's simply more than is necessary for most cases. And similarly, American lawyers in particular conducting international arbitration need to not feel that they have to have depositions just because that's what they're used to in litigation. Often in international arbitration, you have the party's witness statement in advance. You can prepare the cross-examination in advance based on that. So that's one more. Time is running a little short, so I'll cut short there, and I'll turn finally to the role that institutions can play. It's important for them to play a more proactive role. In my view, the institutions that will succeed over the next 25 years are the ones that those best promote the goals of efficiency. And institutions, because they manage these cases, they see the procedures and innovations that are successful in achieving prompt resolution in some of their cases. And they also see the problems that lead to perhaps a schedule of horrors in other cases. They need to find ways to post this information on their websites, properly redacted, of course, so that parties and arbitrators can make use of them. They know they have great mother lode of information, and they need to more effectively communicate those techniques to parties and arbitrators so that the best techniques can be used more broadly. They should also post their statistics so that users know which ones best create an atmosphere of efficiency. And they need to increase pressure on arbitrators to create and then to adhere to shorter and more innovative time schedules. When arbitrators fail to meet them or fail to deliver an award on a timely basis, the institutions should refuse to reappoint them, no matter how distinguished they are. I'll point out two other areas in which institutions have made great strides, which have been very helpful as we move forward. One is that several institutions, the AAA, the Stockholm Chamber, the Singapore Institute, the SIAC, and now the ICC have developed procedures for emergency arbitrators where you need quick relief, need an arbitrator appointed. You can get one appointed within a matter of days, and you can have provisional relief ordered, if appropriate, again, with a matter of days, or certainly no more than weeks. It may be a decision that is contractually binding, or in some circumstances it may be an award that could be enforced, a partial award that could be enforced in a court. But frankly, I thought that parties wouldn't use them because when they needed immediate relief, they would turn to the courts for that because the courts could enforce it quickly. But in fact, the experience of the institutions that have had these procedures in place now for a couple of years is that parties have used them. And for the same reason the parties choose arbitration in the first place, and that is that they want a neutral forum, they want to stay out of national courts. One other area in which institutions have made great strides recently is to provide better rules for multi-party and multi-contract disputes. And again, the ICC rules have allowed for greater joinder and for arbitration of claims under more than one contract in a single arbitration proceeding. So I've given an overview of the challenges we faced, of the role that every participant in the international arbitration process can play in creating more efficient procedures. I hope that there is greater learning in the international arbitration community as we use procedures that are effective and they can get carried on and used by other parties and other counsel. I hope that in-house counsel will play a much stronger role in shaping the procedure and truly saving their businesses money. And I've look forward, again, I thank you for this opportunity, and I'm happy to answer any questions you may have on these subjects. Thanks again.
We always gone very fast, but we do have some time for questions. I've been asked to ask those with questions to approach the microphones. Our staff have already turned on the microphones. This is recorded for the webcast, so please, if you have questions, the microphones.
Without making light of your suggestions, much of it is just plain common sense in these kind of procedures, which means that the parties should understand it to begin with, which to me tells me what incentives to the various groups you've mentioned are there so that they'll actually cooperate and they'll actually do the kinds of things you're suggesting.
Well, I think some of it, some of the incentive would come from greater arbitrator control. If the arbitrators, stepping back, I think parties, while this does make common sense, first, too many parties approach international arbitration either the way they conducted the last case or the way they conduct litigation generally, and don't take advantage of the flexibility that's there. It's an important dispute. It can often involve billions of dollars now, and they feel uncomfortable restricting the procedures in a way that they feel may not get them all of the evidence that they need. They need to be more comfortable with doing that. And that's where the proactive arbitrator can come in, because the proactive arbitrator can step back and say, here's what I think you need for this case, and can push them a bit and make them focus on it. And it can allow, for example, an in-house counsel or an external counsel to be able to say to their clients, this is why we shaped the case in this way, because this is the way the arbitrator suggested. It was early in the case. We wanted to agree with them. We understood the value of their suggestion. In a way, the arbitrator can help save them from themselves and some of their internal pressures.
David, I want to thank you for coming to Cleveland. It's nice to see a fellow Yaley so accomplished, and you honor us by coming to the law school today. With all due respect to the previous gentleman, as a practitioner, what you're saying makes no common sense to me. Very difficult for me to accept any brother counselor advocating lower fees. My question to you is something that has to do with the progression or the history of arbitration internationally. When we were both in school, it was at its infancy, or it was maybe developed after post-war development, coming out of major international trials or whatever. Now, with Henry King gone, it's a brand new world. But I still see much of the rest of the world stepping from the 50s into the 70s into the 90s. And I'd like to get your perspective on say, changes in arbitration in China, for instance, versus some of the more efficient changes that have taken place in the United States and the rest of the world.
By the way, the last speech on arbitration I gave in Cleveland a number of years ago was at Henry's suggestion, so appreciate your mentioning his name. I think the biggest change in international arbitration that's taken place over the last decade is how truly global it's become. I think international arbitration a couple of decades ago was largely focused in Europe and North America. Now you have extremely strong, competent, experienced arbitration counsel in Latin America, in Asia, who lead very large cases. I was talking with Professor Lee at lunch today about some of our mutual friends who are leading Korean arbitration lawyers. And 10 years ago, we used to work with them as co-counsel in a way where we were kind of leading the proceeding and they were providing the local advice. Now, and we've continued to have very strong working relationships with them. But over the last decade, our relationship has changed completely because they are completely able to run the case on their own. And so they may ask us to help on a particular aspect of a case, or they may not ask us at all any longer. And that is true of now Chinese arbitrators are learning that. And I think the CTAC system is becoming more open to the type of innovative procedures that sometimes you see in the rest of the world. And I think that it's a good thing. You know, we want to learn from the systems that arbitrators can and practitioners can bring from around the world. And one of the things I've always enjoyed about international arbitration is that it's a fusing of common law and civil law procedures. And I think the more we have lawyers from Korea and China and Brazil and Chile leading cases, bringing their own different experiences and ideas to bear, it will improve the process.
We had a medical malpractice arbitration format about 15 years ago, and there were complaints that it was being used as a inadvertent discovery tool. In other words, large hospitals would do it just to get a glimpse of the witnesses. Are there any confidentiality provisions now that would make people more cynical to participate?
Most arbitration rules, international arbitration rules, have some confidentiality provisions. And one advantage to international arbitration that's frequently cited is that the proceedings are confidential. That isn't always true under certain laws, and certain rules don't provide the confidentiality protection that one would expect. So if it's important to you, you should really write it in your arbitration clause. I think with respect to that, the IBA rules of evidence in which are often used in international arbitration make clear that documents that are received in discovery in the arbitration are confidential and can't be used for any other process. So I think it would prevent a party from using arbitration just for that purpose.
Thank you so much.
I'd be happy to take the microphone too. Stay in your seats if anyone else has a question.
Any other questions?
As an arbitrator, where you suggest the arbitrator be assertive, do you ever, as an arbitrator, feel that you've lost something or you might be missing something with limited discovery, some important fact that maybe would have come out in a court trial, but with limited discovery isn't available to you as an arbitrator?
I haven't, and neither as arbitrator or as counsel. And it's not just because I always feel that I'm able to get the documents that I need, and in our international arbitration as counsel, even with the stricter standards of the IBA rules of evidence, I've often managed to get documents that are quite incriminating from the other side and which are enormously helpful. One other procedure which is often used, which fits in with your question, is chess clock for the hearing itself. Very often arbitrators will say, we've got this week set aside for the hearing. This is all we've got. In 5 days, we can have roughly 30 hours of hearing time. Each side gets 15 hours. You can use that for your arguments. You can use it for examining the other side's witness or examining your own witnesses on direct or redirect. But when you're done with your 15 hours, you're done. I really like that procedure, both as arbitrator and counsel. I've never, as counsel, felt in the end that there was some important piece of information I wanted to get to the tribunal. In fact, usually we end up early because when you have that type of discipline, you focus on what evidence you really need from each witness. You don't ask repetitive questions of multiple witnesses about the same meeting. Because you get what you focus on who you need it from, and you effectively use either the documents or the testimony depending on what's going to get the information to the tribunal better. So I think it really helps focus the parties, and similarly I think the restricted document production does. I think there are times when you set a certain amount of time for the hearing at the beginning of a case, and once you see how many witnesses there are or what the evidence is, you may find that it's insufficient. And sometimes you'll have to adjust. And I've done that as counsel and I've done that as arbitrator. And sometimes that's meant weekend hearings before or after the week that was set aside. Sometimes it's meant having to break it up, although usually we're able to avoid that. But to give you an example, in a multi-billion-dollar expropriation case, that I tried as counsel a few years ago. The arbitrators had set aside 5 days for the hearing. Turned out that between the fact witnesses and the expert witnesses, we had 23 witnesses who had to be heard. All of their witness statements and expert reports were, of course, submitted in writing in advance, so we had that time saving. The arbitrators extended the hearing by 3 days by using the weekends on either side. We very effectively got 23 witnesses done in 8 days of hearing. And again, I didn't feel that there was anything left unsaid at the end of that.
All right, First, please join me in thanking David Rifkin, our